Thank you for attending our third event in the Future of the President's Pardon Power series, titled Managing the Pardon Power, Should the Justice Department Remain the Gatekeeper? The series is jointly organized by the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law, the Collateral Consequences Resource Center, the Federal Sentencing Reporter, and the David F. and Constance B. Gerard DiCarlo Center for Ethics, Integrity, and Compliance at Villanova University Charles Widger School of Law. Before we begin, we just have a few notes we'd like to share with you. First, to streamline the appearance of the event today, we suggest that you hide non-video participants. Second, we want to draw your attention to the Q&A function at the bottom of your Zoom window. You may submit questions at any time during the presentation. Third, please note that auto-generated transcription has been enabled for the event. To change how you view the automated transcription or to hide it, click Live Transcript in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on the event page and social media channels as soon as possible after the event. Thank you again for joining us, and we hope you enjoy the event. Doug?
Actually, I think, Steve, are you going first?
I think I am.
All right.
So good afternoon, everyone. I'm Steve Channinson, along with Doug. I'm one of the managing editors of the Federal Sentencing Reporter, and we're thrilled to welcome you here today and to start our third and final session in this series. This series, as you can see on the screen, in many ways grows out of volume 33, issue 5 of the Federal Sentencing Reporter, addressing all types of questions of clemency. And with many thanks to one of our panelists today, Margaret Love, who was the guest editor and has been before for the Federal Sentencing Reporter on these issues, going back 20 years. When we addressed these issues and raised a similar question in an article entitled, Does the Fox Control the Pardon Henhouse? So with that, I want to introduce Doug Berman, who is the other managing editor of the Federal Sentencing Reporter and the director of the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law. Doug?
Thank you, Steve, and thanks to all of the panelists and the attendees for making time today for what to me, I can't help but say is the most exciting of our three panels. Maybe it's just because it's the one today. The other two were really exciting when they were going on, and a good reminder that the videos of all these panels are going to be archived on our websites, and so look out for that. But today we have the incredible honor and opportunity to hear from four true experts, each of whom bring a somewhat different perspective, both to the past, the present, and the possible future of the president's pardon power. And as many of you who may be attending know, the Justice Department has historically played a central role in the way in which the president uses his clemency authority, and whether that should persist and what it should look like is part of what we'll be talking about going forward. I'll introduce each of the panelists just to give a roadmap for where we're headed right before they give maybe a 5 to 10 minute initial accounting of kind of their perspective on these issues. And then I'll have a couple follow-up questions and then also open it up for questions. As mentioned, you can use the Q&A to weigh in some questions, and I'll be monitoring that and bring that to each of the panelists. We're going to start with Professor Jeffrey Crouch. He's an assistant professor of American politics at the School of Public Affairs at American University, and is a sort of not just a leading expert, I think the leading expert on the history of the pardon power. And he's going to start by giving us something of a historical overview of the Justice Department's role in this process, and in so doing, kind of give us the background we need to then move on to a more critical examination of how they've been performing that role more recently, and how else we might structure this authority. So with that, Professor Crouch, go right ahead. Except we need you to put on your unmute.
Sorry, I'll start over. Sorry.
No worries, please do. Thank you.
So thanks to Doug and Steve for inviting me, and thanks to Margaret for asking me to contribute a piece to this issue of Federal Sentencing Reporter. Thanks to my fellow panelists, and thanks to our sponsors. My role today is really going to be to kind of set the stage. I'm sort of the opening act for the performance to follow. And what I want to do is just talk a little bit about the president's pardon power, and then lead that conversation into a discussion of kind of the history of the Justice Department's role. in the clemency process. So the president has the responsibility to grant executive clemency or use the pardon power, depending on how you want to think about it. And this is in the Constitution. It's in Article 2 of the Constitution. And the language is that the president has the ability to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. That's the president's constitutional charge. And presidents haven't done this all on their own, starting really with Abraham Lincoln. In the context of the Civil War, the presidents have had bureaucratic assistance in going through all the clemency applications. And the first official office was created on March 3rd, 1865. This is the pardon clerk that was created in the office of the Attorney General. And note that the Department of Justice hadn't actually been created yet. That didn't happen until about 5 years later in 1870. But we had a pardon clerk at that early date. And then in 1891, the pardon clerk was replaced by an attorney in charge of pardons, pardon attorney, if you will. Stepping back a moment, in 1852, the Secretary of State and the Attorney General at the time had decided to split the responsibility for clemency within the executive branch. And so this is how it was going to work. The Attorney General alone would handle clemency petitions. The State Department would be responsible for creating clemency warrants. But that system changed in 1893 when President Grover Cleveland issued an executive order that moved the responsibility for creating clemency warrants from the State Department to the Department of Justice. And so everything's now in the Department of Justice. And if you look back throughout 200 and some years of the use of the pardon power by the president, it's been a pretty good working relationship between the president and the pardon attorney. They regularly created a substantial number of clemency grants that occurred throughout a president's term in office. And I quote one of our fellow panelists today, Margaret Love, who argues in one of her many works on the pardon attorney's office, quote, almost every year between 1900 and 1980, there were over 100 grants of pardon and commutation. And indeed, throughout the 20th century, presidents saw clemency as, quoting Margaret again, a regular part of the housekeeping business of the presidency. So there's this long history of the pardon attorney helping the president to come up with worthy recipients for clemency. And it's been historically a fairly regular process, for the most part, a fairly uncontroversial process, as the housekeeping quote points out. However, something changed in the late 1970s and into the early 1980s. And we had the situation where presidents of both political parties who had generously granted clemency for decades, all of a sudden were much, much less generous going forward. And there's really a couple key reasons for this. One of them has to do with the outlook of the president, the idea of this tough on crime attitude that was really ushered in by President Ronald Reagan and then followed by his successors. And then the other big factor was a decision that was made by Griffin Bell, who was Jimmy Carter's attorney general. And he basically downgraded the importance of clemency by delegating the responsibility to recommend action on clemency petitions to the same folks that are supervising federal prosecutors. And so taking these two factors together, the attitude of the president to be tough on crime and the downgraded, if you will, importance of clemency within the Department of Justice, those two factors together really de-emphasize the importance of clemency to presidents after Ronald Reagan. And just a few case examples here. We all know about Bill Clinton's controversial last-minute pardons, but the reason that that situation occurred is basically the confluence of several different factors. So for one, Clinton basically neglected clemency throughout his presidency. And of course, he served 2 terms. As he neared the end of his second term, he decided that this would be a good time to really establish a clemency record. He was actually, he wanted to match the number of clemency grants that at least Ronald Reagan had granted. And so towards the end of his presidency, he had this urge to work very quickly. And in order to do that, he needed to figure out a way to bypass the pardon attorney. Of course, the pardon attorney is going to give a detailed review, which in a lot of cases can take weeks, months, or years. And in order to compile the number of pardons and commutations that he wanted, he basically invited petitioners to submit their applications directly to the White House, to his White House counsel. And that didn't turn out very well for him. He ended up pardoning on his way out the door 177 people, pardons and commutations, 177 of them. And among those folks who received clemency were Mark Rich, the fugitive financier, Clinton's half-brother Roger Clinton, his former business partner Susan McDougal, and many others that were controversial in their own way. George W. Bush, not as controversial as Clinton generally. He pretty much followed the pardon attorney's recommendations. He too had the same last-minute rush on his way out the door. A lot of folks asked for clemency. Unlike Clinton, though, Bush generally resisted that. And so this was kind of the groundwork when Barack Obama became president. And you see the same dynamic again. Obama got to his second term. And in this case, he was frustrated by how few positive clemency recommendations he had received from the Department of Justice. And his response to that was to create what was called a Clemency Initiative. And the Clemency Initiative was designed to target really low-level drug offenders, nonviolent drug offenders. And in order to find those folks, the Justice Department basically enlisted the help of a number of outside organizations. And so the way this would work is these outside organizations would screen applications. They would try to find the ones that were the most worthy, basically. And then they would forward those applications to the Department of Justice, where the pardon attorney would then do their regular review. And this process, folks have different perspectives on this. Obama ended up granting over 1,700 sentence commutations, largely as a result of this process. But he also ended up leaving a backlog of about 11,000 requests for his successor, Donald Trump. And so, this is a process that could have worked better had it been planned out for a longer period of time, had different decisions been made at different points. It's a really interesting use of clemency by Obama, and it could be emulated by his successors. But in the case of Donald Trump, that wasn't the case. Donald Trump basically worked outside the Department of Justice's apparatus. He appointed his son-in-law and advisor, Jared Kushner, and his White House counsel, Don McGahn, to come up with a way to evaluate clemency petitions, to come up with a committee or some body to do that. And the early media reports out of the Trump presidency suggested that Trump didn't really have a principled approach to clemency. The word that was used by the source was impulsive. And basically the way it would work would be, according to the source, the president would watch something on television, or he would read a newspaper story, or someone would catch his ear and tell him about their particular situation. And those were the cases that he generally granted clemency on. If you look at his final clemency record, out of 238 clemency grants, roughly 25 of those went through the pardon attorney's office. So a really unusual approach by Trump, very personalized clemency, and again, not using the usual processes, not creating that separation between the president's own, life, friends, etc., and the applicants. And instead, it was actually the opposite. Trump was looking for that personal connection for the folks that he granted clemency to. And so it kind of begs the question, well, what do we do now about the pardon power? There's a new president, there's a new attorney general. Is there a way to make the review process better? And my fellow panelists have some good ideas. They have different approaches to this. One option that merits some consideration would be probably to just reform the current system. With the new president, there's a new attorney general. There can be a new attitude in terms of what the priorities are. And it remains to be seen what's going to happen with President Biden and Attorney General Merrick Garland. So far, we're roughly 8 months into President Biden's term, and there haven't been any clemency grants. Although I'm sure most of you know that there's been talk about Biden using clemency relatively soon, and possibly on a large scale. But in any case, with that introduction established, I will now turn things over to the rest of our esteemed panel.
Thank you so much, Professor Crouch. I appreciate that. Was a terrific accounting and efficient, under the 10 minutes even, of kind of where we've been. I'm going to now turn to Margaret Love, the Executive Director of the Collateral Consequences Resource Center. She's had, in some sense, a front seat to a lot of this recent history, having been the former U.S. pardon attorney for 2 presidents, I believe, and then representing a number of pardon applicants since then. And so I know you have very much both a kind of an insider and a close to the sidelines perspective on how it's been done in the past and the Justice Department's role. Please, Ms. Love, go ahead and sort of give us your take and your view of not just where we've been, but where we are and where you think we might be going. Got to unmute again. There we go.
We'll never learn, will we? I'm very happy to be here, Doug. As always, I'm delighted to talk about the pardon power. As the keeper of what Doug referred to as the hen house during the 1990s, I had a front seat, obviously, at the demise of the regular pardon process that Jeff so ably discussed. And it's interesting that I've been thinking about the Faulkner quote about the past not being dead. In fact, it's not even past. There have been suggestions, a lot of suggestions about how to reform the pardon process. I've gone back and forth myself. And I guess I've come to the conclusion that before you really can decide how to reform the pardon process, you have to decide, what do you want to do with this power? If you want to go back to the system that existed before a parole authority, for example, back before 1910, I guess was the first, not the parole board, but there was a paroling authority in federal prisons at that time. And pardon really was used as an all-purpose mechanism to sort out injustices in what was a pretty crude justice system. Many believe that we are back in a period of a pretty crude justice system. So if you want pardon to do that, reducing prison sentences, removing collateral consequences, restoring rights, if you want pardon on a large scale, then I think you have to be prepared to create a pretty large scale bureaucracy to handle all the cases that will come in. And there will be many, many cases that will come in because there is a big pent up demand. Not only do we have 14,000 applications that are currently pending in the pardon attorney's office, there would probably be many, many hundreds, perhaps, of thousands of people applying for pardons. And of course, most people in the federal prison system would prefer not to be there, so they would also file applications. So if you're going to use pardon on a large scale, then you need to create a bureaucracy to handle it. Now, whether that bureaucracy is located in the Department of Justice or not is a question. The system in justice worked pretty well, as Jeff was describing, until about 1980. And at that time, there was a change in the way the pardon power was administered and a change in the attitude of the president. So Jeff described that very well. And in fact, the strangulation, if you will, of the pardon power and the pardon program led to a lot of difficulties for the president. And I would say it's not an exaggeration to say that when I was pardon attorney, the program was seen as a Justice Department program to keep the president out of the Justice Department's business. And so that was not terribly helpful to the president. And Bill Clinton certainly suffered from that. Barack Obama suffered from it. So here we are now. And if you decide you want to have large scale use of the pardon power, then you want a big pardon board, perhaps. If you want some alternative way of handling the cases that would come into the pardon office, then I think you may have something a little more nuanced. The panel last week talked about funneling cases into the court system. There was a proposal in 1919, of all things, more than 100 years ago, by the Attorney General to have a pardon commission. And the Attorney General made this recommendation in his reports every year to have a pardon commission. He wanted the cases taken off his desk. And in fact, what he got was a parole board in 1930. And the pardon caseload was greatly reduced because the parole board took off so much of the workload. Maybe we need something like that now. Maybe a board of judges, former judges, to take some of the load off the president. So in short, I don't want to go on too long here, but I do think it's really important as a prior issue to decide how you want the pardon power to work and whether you want it to be an all-purpose corrective for the justice system, or whether you want to sort things out a little bit and funnel some business to the courts, funnel some business to an administrative agency. The fact I've often said that the president is a one-man gun licensing bureau for people with federal convictions is just a little ridiculous. But that in fact is the only way that a person with a federal conviction now can ever go hunting again. Putting that authority in an administrative agency makes a lot of sense. So for me, I would sort out the business that the pardon power does, redistribute it, and then let the president be advised directly by his attorney general on how he wants to use his power and to use it selectively. Public policy issues are pardon is a tremendously effective way of communicating policy priorities. So I do think that having the Justice Department involved is good both for the Justice Department and for the president. So I wouldn't take it out of the Justice Department, but I would put it back the way it was before Judge Bell delegated the power and essentially demeaned the function within the department. So that's my solution. It's kind of a nuanced one, but that's what I would do.
Thank you so much. Terrific comments and very thoughtful. You know, you can't figure out how to get somewhere until you know where you want to be going. And so it makes a lot of sense to make sure we're talking about and thinking about, and in the tail end after the initial presentations, maybe we'll have some more discussion about just what the pardon power should be used for. I'm going to turn to Paul Larkin now, who's the Rumpel Senior Legal Research Fellow at the Heritage Foundation. And I know he's written a lot about the pardon power, in particular has, I think, an especially interesting vision of reorganizing the process, but doing it through the White House and particularly through the Vice President's office. And so, Paul, if you're available to turn your camera on, and I'll tell Ms. Love to turn hers off, so you get the stage to tell us about your thoughts on how this should be done, and you certainly can speak to as you see fit. You know, what you think the power is there to do, and whether you think the current status quo is irreparably broken or just needs a few tweaks along the lines that you're going to suggest.
Thank you very much, Doug, and thank you, Margie. I'm honored to be on this panel, and I'm very grateful for the opportunity, at least to give you a little summary of the sort of views that I have on this matter. As I see it, and as I think there is now a consensus out there in the legal profession among people who have thought about clemency, the problem with the DOJ pardon process, if you will, the DOJ clemency process more generally, is twofold. One is that the Justice Department has a monopoly or a stranglehold, as Margie put it, over the clemency process. And two, DOJ suffers from an actual or apparent conflict of interest because it prosecuted everyone who was involved in that process. Now, with those being the two principal problems that we have to deal with in terms of funneling clemency applications to the president for his or her decision, it seems to me there are three options available to us. One is to reform the DOJ process. Another is to transfer that monopoly elsewhere. And a third one is to create a new parallel clemency office outside of DOJ. At the end of the day, I think there are serious problems with options 1 and 2, that is reforming DOJ or establishing an independent agency. I think option 3, having a parallel agency, is best, but I think the best location for it is in the White House. First, why can't we resolve the problem simply by remedying the structures at DOJ? For the same reason that a tiger can't change his or her stripes, DOJ can't change its nature as a prosecutor. It's built into DOJ's very DNA. In fact, the person who is now responsible for managing the clemency process at DOJ, the Deputy Attorney General, is the same person who is responsible for managing all the criminal litigation that is conducted by the various 93, in fact, U.S. attorneys and the divisions of the Justice Department with criminal prosecution responsibility. Even transferring this to the Attorney General isn't going to make a great deal of difference, because the Attorney General is going to want to know what the deputy thinks. And the deputy, as I said, has got very conflicting attitudes about the whole clemency process. The second problem with trying to remedy the DOJ system is a very simple one. People don't like admitting they made mistakes, and DOJ uses people in this process. Not very many prosecutors, whether they are political appointees at DOJ or in the U.S. attorney's offices, or even line attorneys, are going to want to admit they made mistakes. They prosecuted someone who turned out to be innocent, or they prosecuted somebody who should not have been criminally charged and maybe left to the civil authorities to handle, or who received an unduly severe sentence. Most people aren't willing to admit that the case they were involved in was a mistake in its initiation, was a mistake in its culmination, or was a mistake in its remedy. And therefore, we shouldn't try to fight that natural human instinct. We should recognize it and try to deal with it by giving somebody else that responsibility. Now, option 2 would give that responsibility to an independent agency, say something like the Sentencing Commission. The problem is the Sentencing Commission is a very bad analogy for this. Why? The Sentencing Commission was bound by all the provisions in Title 18 that established limitations on what the sentences could be. Certainly, the Sentencing Commission could not authorize a district court judge to impose a sentence greater than what Congress had specified in the statute. So the Sentencing Commission was limited by positive law in exactly what it could recommend in this regard. That's not true in connection with the clemency process. The clemency process is a prerogative of the President of the United States, and so an independent agency could recommend clemency willy-nilly, even if it thought that the President might disagree. Why? Well, an independent clemency agency is not going to be subject to presidential control. In fact, if people on the Hill are involved in the selection of the members of the commission, the independent members of this commission are going to have their own constituencies. And finally, the independent members bear no responsibility for their recommendations. The result is you're likely to see political cronyism of the worst type work its way into clemency recommendations. That will be good for the cronies that receive positive recommendations. It'll be good for the media that always likes to play up differences between the Article 1 and 2 branches. But it's not good for clemency applicants who don't have a rabbi in the White House. It's not good for the public, and it's not good for the criminal justice system. The third option seems to me to be the best. What we should do is establish a White House clemency office that is part of the executive office of the president. The president and the vice president should select advisors to the president in this regard, and the president should appoint the vice president as his or her principal clemency advisor. Now, what are the benefits of this approach? One is the vice president is not involved in the criminal justice system, so he or she does not suffer from the same conflict of interest that the Justice Department does. Second, the president chooses the vice president, so presumably the president has picked someone who he or she believes will remain loyal to him. Third, the vice president has better access than anyone else in the administration or outside the administration in meeting with the president. Ever since Walter Mondale, or rather ever since Nelson Rockefeller, vice presidents have had weekly meetings with the president. And in the Bush Jr. White House, Dick Cheney would meet with President Bush Jr. several times during the day. So the vice president will know what the president's attitudes are towards clemency, and presumably, because he's loyal, the vice president will implement them the same way that a law clerk would implement directions from a judge how to write an opinion. Fourth, because the president gets to choose his vice president, presumably he picks someone in whom he has great confidence and who has judgment that the president wants to hear and can rely on. Fifth, the vice president might actually, if he or she was a governor, have had experience in the clemency process, and therefore the vice president knows the difficulties involved in making these sorts of judgments. Finally, sixth, under this approach, the Justice Department still would have the right to offer an opinion. It still would have a a Justice Department Office of the Pardon Attorney. And every application that was submitted to the White House could be submitted to the Justice Department as well. After all, every president is going to want to know what his or her attorney general thinks is the right solution for this sort of problem. If nothing else, it is a way of protecting him or herself against the blowback that will happen if clemency applications wind up being granted and then something untoward happens, like the person commits additional crimes. The Justice Department knows these applicants probably better than anybody else, and therefore the president will want to know what DOJ thinks, but it just doesn't want to give DOJ the opportunity to strangle a clemency application in the cradle. Now, how does this fit in with the overall approach to clemency? What do we think it should have? I think you have to treat the pardon issue and the commutation issue as being very separate. Generally speaking, the most important function I think the president can serve today in clemency is not trying to resentence people on a case-by-case basis. It's acting on behalf of the nation to express forgiveness on behalf of the public for something that someone has done, someone who has admitted that he did something wrong, someone who has turned his or her life around, someone who it is clear is not going to reoffend, and someone who perhaps has an extraordinary type of case that justifies a pardon, despite the fact he committed a crime, perhaps even a violent crime earlier on. After all, those who are familiar with the New Testament, Acts, for example, and the letters from Paul, know that Paul was involved in some very unsavory activity, and yet he turned his life around and was an example of metanoia. The clemency process doesn't work as well when the president tries to deal with commutations. Now, yes, there will be certain sentences that are just off the charts, but rather than go through and resentence each offender, what we ought to have is either someone else look at those sorts of problems, or for the president to make category-wide judgments. A president should decide, I don't believe in the death penalty, no one should be executed. I don't believe in life imprisonment without parole, and so I'm going to reduce every sentence to a parolable one. Some sentences shouldn't result in imprisonment at all, and therefore any sentence like that should be commuted automatically to time served, or that he says he will commute in the future in that way. It's not a good use of the president's time for him to try to second guess a sentencing judge. Just as we don't have sentencing judges try to second guess the president's foreign policy decisions, we shouldn't have the president second guess sentencing judges. So commutation decisions should be treated differently, but they can be treated within an overall framework that may require some congressional intervention to deal with the length of sentences, but generally speaking is still worthwhile to have in the White House. Thank you.
Thank you, Paul. I appreciate that, and getting us in just in time, so we have plenty of time to now hear from Rachel Barkow. Professor Barkow, actually Dean Barkow, is Vice Dean and the Charles Seligson Professor of Law at New York University School of Law. She's written extensively and had lots of recommendations about other ways to restructure the pardon power. And rather than preempt her, I will just turn it over to her and look forward to hearing from her, after which I'll have lots of questions for all of you. So thanks so much. Great work, everybody, so far.
Great. Thanks so much, Doug. And thanks to all of you for being here today. So thankfully, some of my time I can take back, since Paul did such a good job describing some of the problems with having the Department of Justice handle clemency. I want to mention just a few more, in addition to obviously the inherent bias, which I think is by far the biggest issue. It's also important to recognize some other problems that currently exist with how clemency is working at DOJ. So I checked this morning, and there is a backlog of 15,000 petitions waiting in a queue at the Department of Justice. And I think it's worth thinking about why those are not moving more quickly through the process. There's multiple layers at the Department of Justice. It's a big agency, and it's an agency that has it go through a couple layers at the pardon attorney's office. And then even if you somehow made it through there, you'd have to go to the Deputy Attorney General's office, which, as Paul mentioned, is the same place that supervises and is in charge of criminal cases at the department. So the bias is clear, and the layers of review mean that you have to go through multiple ones even to get to that final check in the DAG's office, and you're likely to get a no once it makes it all the way through. So I think keeping it at the department really requires asking, why would you do that? And I think Jeff pointed out, even the fact that it ended up there initially was kind of a historical accident. It wasn't like someone said, wow, where's the best place to review prosecutions? How about the prosecutors? I don't think anyone would say that. And that's why no state has a model that looks anything remotely like this. This is a weird curiosity of the federal system that doesn't make any sense. So I think taking it out of the department is definitely the right course. I think that's why most of the candidates who were running for president thought that was a good idea and put it in as part of their platform. I think that's why it made it into the Biden-Sanders unity platform. Inexplicably, it's being ignored now by the Biden half of that platform, which I think is a real shame that it's still left in the department. And I guess just to give you an anecdotal sense of what's wrong there, during the Obama presidency, when President Obama said, I want to use this power and I want to use it robustly, you still couldn't get through the Department of Justice and get that old machinery working to do what the president wanted. And we had a little kind of pop-up clemency shop that Mark Osler and I put together. So we had many, many petitions there, ultimately got 96 of them granted. So we have pretty good familiarity with the cases and how they were processed. It was inexplicable which cases were granted, which ones were denied. We heard things like, well, we couldn't grant this case because this person has an arrest, not a conviction, but an arrest for something. And most importantly, every petition starts with the Department of Justice going to the prosecutor's office that brought the case and saying, hey, what do you think? So if you think that's a fair process, it's basically like you're watching an NFL game and, let's say it's my Broncos versus the Patriots and the call goes against the Broncos. And the first thing they do is turn to a Patriots fan and say, hey, what do you think? I think you know what that answer is going to be. This is not an unbiased source of feedback. This office that they are consulting to get their opinion on was the office that brought the case in the first place. They invested resources. They put a lot of hard work into it. You see time and time again, if you ever read articles on retroactive relief or compassionate release or any other mechanism that lets somebody out of prison before their sentence was otherwise supposed to be up, you'll hear prosecutors talk about all that hard work for nothing, or it somehow seems like a diminishment of what they did. And I just think that's the kind of cultural framework and bias that makes the department a poor source for this authority, whatever you're going to use it for, whether you're going to use it in a much more limited way, as Margie described, or you're going to go big, which is what I would advocate it should be used for. I think the department is the wrong place no matter what. You got to put it in the hands of people who are well equipped to make these decisions. So that brings me to, what is it you want to be doing when you're making clemency determinations? So the two major categories are pardons. So someone has usually someone according to DOJ process now, they've served their sentence, they've been out, and they would like to get their record cleared so they can get, as Margie said, a firearms license or some other license that they're prohibited from getting because of their conviction. They need relief from those collateral consequences. Or it's commutations, which I think is, for my money, the more significant and important use of the power these days when you're looking at a federal prison population that's, It has been the largest number of people incarcerated of any jurisdiction in the United States, bigger than any state in recent years for a lot of the time. And there's no parole. And to the extent people have pointed to other second look mechanisms like compassionate release and going to judges, I'll point you to Sentencing Commission data that just came out again today, tracking the compassionate release. And what you find is district courts are all over the map. Some of them, like Massachusetts, they're granting 49% of their compassionate release motions. But if you are unfortunately in the Western District of Kentucky, you're looking at a 5% grant rate. So I don't think judges are the answer. I don't think funneling this through another process. I'm all for compassionate release. I think it's important. It's good to have that second look. But it doesn't diminish the fact that you do need presidential authority over this. And one of the key reasons that you do is because different prosecutors' offices around the country do very different things. So a president is uniquely situated to even out those differences and make sure that the offices are following the president's policies. And when a new president comes in, just like when a new president comes in on the civil side and says, I don't like what that last president's EPA did. I want to do something else for the environment, or I want to do something else related to occupational safety and health. A new president can come in and say, I don't like the way that past president dealt with criminal punishment decisions. And in particular, what the Constitution gives the president the authority to do is say, I think that last president was too harsh, and can come in and remedy those kinds of harsh decisions. So I am in favor of a bold use of clemency because we don't have alternative mechanisms in the federal system that work, and we don't have parole. Compassionate release is limited. We need it, and we need it desperately. And there's a 15,000 petition backlog right now, and those people are all waiting. So the need for reform is urgent. I would argue that the best approach, it's not that far off from what Paul was discussing. I think we need an advisory board of some kind. And people like an independent commission. There's no independent option because the Constitution gives the president the sole authority over clemency. So any kind of commission or board model you create is going to be the president's going to fully control it. And that's how it should be under our Constitution. But what I think a president could find useful is appointing a group of people who have the relevant expertise to make these decisions. So when we're thinking about why you would maybe want to take a second look at a sentence, I think one of the primary things you'd want to be looking at is, has this person changed over time? So you'd want people who are expert in things like rehabilitation, people who understand reentry, formerly incarcerated people who understand what people who are imprisoned are going through. They could help you read a prison record and really explain how extraordinary what programs someone has done really are. You want people who really understand how to look at those files and get the reentry decision that the president would be making if it was a commutation. So you want people with relevant expertise. And frankly, I think the other thing that a president would want is some political cover, because at the end of the day, the reason that the clemency numbers have plummeted in the way that Jeff has described is all politics. No president wants to have the Willie Horton ad about a clemency decision. And so they're risk averse, and they look at this as kind of a losing proposition that they don't take a chance on. And so I think the key is to create a board that gives some political cover, where a president can say, hey, I was following the advice of this expert blue ribbon body that included people of both parties and agreed that this was the right decision to make. And when we look at states where there's actually a decently functioning clemency process, it looks more like that, with a board that can give the president some cover. President still picks the people, so I'm not suggesting it's independent in any way, but the president could be savvy about who is going to be put on there. And when those folks are making those decisions, they'll be guided by what the president says is the president's priorities. At the end of the day, we can't do anything about that. If you have a president who's not that interested in sentencing reform or reducing sentences, you're kind of stuck. But if you have someone who wants to do it, if you have someone like President Obama who wanted to do something, having a board model will allow that vision to be achieved, and to be achieved in an efficient, effective way, as opposed to the haphazard approach that was the Clemency Initiative. And I guess if I was just going to end on a note, it would be, I think modeling any future clemency reform after what happened during the Obama administration would be tragic, because anybody who participated in that process, who had cases that went through that process, knows exactly how awful it was. There were far too many deserving people who fit the criteria who were just left behind. It was too haphazard. haphazard and it didn't work. So I think the new model has to be different. It doesn't mean you swing all the way to the Trump, I'm only going to give clemency to my friends model. There is a third way, and the third way is to take the best of what we know from administrative law and other contexts and have a board that knows what it's doing, give advice to the president.
Thank you so much, Professor Barkow. And I'm going to go to first names from here on in, since I'm lucky enough to know all of you personally, and I'm real excited to sort of go to a follow-up set of questions. I've got two, one from the Q&A, one that I think I actually may come from also another person, but we were talking about before as well. And everybody should feel free to turn on their cameras if they would like to, although Rachel, is going to sort of come to you first, because let's imagine I'm a member of Congress or a staff for a member of Congress. Sounds great. That is the way this ought to get done. Let me go pass a bill to get it done. Is this something that Congress can play any role in helping to achieve? And I guess that would ultimately come back to you, Paul, as well, that, obviously there are ways in which Congress could, seek to empower the vice president or others in other branches to do this kind of advisory work. And I think I know you, Rachel, have some views on the constitutionality of that. And even if Jeffrey, you're going to come back online, I don't know if you have a sense of the history of the law here, but this is an area that tends not to be heavily litigated, so we don't have conclusive rulings. But I certainly think this is something that there are members of Congress and others talking about the need for reform along the lines that we've been discussing. The question is whether they're permitted to play a role, or what kind of role we might imagine them usefully playing as we talk through reform.
So I guess if I could so first let me just say that the irony, of course, is Congress can do all these things directly with its own powers. So if Congress thinks sentences are too long, right off the bat, it should be making any sentence reduction retroactively available for people. One of the reasons we have the backlog we have is Congress doesn't do that. And so you have people who are serving sentences right now that they would never get today because the law has changed. So I think Congress should clean its own house. It should have retroactive sentencing adjustments. It should have ways that you can get your record expunged so you don't need to get a pardon. There's lots of legislation that can be essentially replacement functions for all the things that presidential clemency is doing. And that would be the first thing I would tell them to do, because then you really could have this set up in a functioning way. What Congress can't do is tell the president that the president has to exercise the clemency power in a particular way. That's just not the constitutional framework we have. So I do not believe it would be constitutional for Congress to pick who a president has to talk to before making a clemency decision. I think the president could ignore that completely and be within his, her, their presidential rights to do so. I think the one thing Congress could do is provide funding, as it does now, for the pardon attorney office. So it could provide funding for a board, and I think that would be great if it did. But other than that, I think Congress should deal with these issues by passing legislation that deals with these issues.
Doug, let me follow up by saying I agree with what Rachel just said, both what she just said in response to the question and what she said during her presentation. It seems to me it makes no sense whatsoever for Congress to reduce a sentence and not make it retroactive. If whatever the new judgment is, it represents the best thinking or the best politics, since politics is involved in this too. Either way, if they reduce a sentence from 10 years to 5 years as the max, that items as a matter of law ought to be applied retroactively. And what they ought to do is, in fact, revise the current statute that works the other way. There's a current law in Title 18 that says they're presumptively not retroactive unless Congress goes out of its way to make it retroactive. Modify that statute so that the presumption is that they automatically are retroactive. Then there are a few other things that Congress can do without stepping on the president's toes. As Rachel said, fund this office. You're going to need people just to handle the bureaucratic or parts of processing applications, getting opinions from others, talking to others. And these things can't be done without money. It's just that simple. You're going to need to fund this process. Okay. Plus, if you want to pay additional career people at the White House to handle these in an office of clemency, you're going to need Congress to fund that as part of the executive office of the president. You're also going to want them to fund it if it's not in the White House, if it's someplace else. So Congress should have to do that. But then there are two other very practical types of legislation Congress should adopt. First, it should make sure that the deliberations and work of this committee can be done in the same secrecy that Congress members expect their deliberations over legislation. So it should not be subject to the Freedom of Information Act, and it should not be subject to the Federal Advisory Committee Act. As a practical matter, the Federal Advisory Committee Act has been interpreted by the DC Circuit to give the president some leeway in this regard, and the president needs it. But rather than go through separation of powers litigation, let Congress just make clear that it can operate by giving opinions to the president that won't show up on the newspaper the next day. Finally, Congress should make it clear that the people on this committee should get access to pre-sentence reports because they are critical. Anything like that, whether it's the pre-sentence report, appeal recommendations, non-appeal recommendations at the Justice Department, other internal memos, yes, the president can order the Justice Department to send over a variety of materials that DOJ uses in deciding whether to bring a case, like a prosecution memo. But pre-sentence reports are governed by law, and we want the pre-sentence reports to be accessible to people making these recommendations. So Congress should step in and address that problem too. And all of the recommendations that I've just mentioned, like the ones that Rachel mentioned, are ones that are best done by Congress to make it clear that they want this body to address this problem in a degree, regardless of who is in the White House, a president, that it's a Republican, a Democrat, a conservative, a liberal, whatever, that they can do, that president can do his or her job in a way that ensures confidentiality, loyalty, confidence, but accurate information. So there are things Congress can do in this regard, and I urge Congress to do it.
Other panelists thought about Congress's role?
Yeah, sure, I have. Thanks, Doug. Yeah, well, I may surprise Rachel and Paul to say that I agree with them entirely. One thing I wanted to point out is that we have been here before. This happened in 1910 when Congress passed a statutory parole authority. The Attorney General managed both pardon and parole through the 1920s. And then there was a statutory parole board created. And that took an awful lot of the commutation business off the president's desk. Now, nobody wants to hear the word parole, but we have a whole wonderful blossoming of the law in second look statutes. The American Law Institute has recommended that there be some mechanism, probably in the judiciary, that would be responsible for taking second looks after 10 years, 15 years, whatever. And a function like that, perhaps district by district, but perhaps a national function like that, could be really a great help to the president, and I think would be a very fair, fairer than clemency. God knows, clemency by its nature is unfair. It's just the nature of the beast. So, and I also just wanted, I just feel like I need to respond to this notion of the department having a fatal conflict of interest. It really doesn't have a fatal conflict of interest. It worked great for 100 years. And the prosecutors were basically the main officials in charge of recommending clemency. And 50% of the cases that applied got it. So under the old system, as long as the Attorney General personally had a role in this process, as long as the pardon attorney had standing in the department to go toe-to-toe with the US attorneys, as long as the US attorneys were very clear about what their role was and what the standards were, I think it could work. And I think that as I said before, I think a kind of a combination of approaches to the conceded problems that we have would be a better service to the president than simply deciding to cut the department out entirely, because it is harmful to the department itself, I think, to not have this ameliorative influence. I think it's high time that the prosecutors in the department get on board, for example, and stop opposing sentence reduction motions that are being filed, stop appealing, and understand what the president's agenda is. They are presidential appointees. So I don't quite understand this culture of the department unchanging. I used to work for Attorney General Thornburg, and boy, he would get everybody in the great hall, lock the door, and give the U.S. attorneys their marching orders. And so that can be done. Now, it's not perfect. Nothing's perfect. But at least I think we can have a kind of a nuanced approach if we identify the problem and decide what the most efficient and fair way is to solve it.
I'll use the moderator's privilege. I want to make sure Jeff gets a chance to talk on the Congress issue, but it's sort of a Congress point that follows up Margie's point. You could have asked me 15, 20 years ago whether Congress would change the culture when it comes to crime and punishment anytime soon, and I would have thought no way. And now, whether it was Representative Sensenbrenner or Senator Grassley, who's now leading reform efforts, cultural change is possible. I just know that is true. Whether it is inside DOJ these days, time will tell, but I do think it's valuable. And maybe this is the right way to queue up somebody who's focused on history to sort of be a reminder that what may be seeming an unresolvable conflict at time one might not look that way at all at time two. So go ahead, Jeff, you have certain thoughts about Congress's role.
Just very quickly, I just wanted to kind of piggyback on what Margie just said. Biden is new, Merrick Garland is new. There's an opportunity to change the culture there. And it's not unusual in the bigger picture that Biden hasn't done anything yet. I didn't mean to give that impression earlier. Presidents generally don't do anything with clemency for sometimes years. Obama and George W. Bush didn't do anything with clemency for almost 2 years. Trump did very quickly after 7 months, but the last president to act that quickly on clemency was George H.W. Bush. So, it's still pretty early. And, we do hear these rumblings about, kind of imminent decisions coming on potentially, hundreds or thousands of folks. So, from my perspective, it kind of makes sense to give him a chance and see if this is maybe the moment where things can change.
Okay, Rachel, I'll let you have the last word on this topic before I turn us to a more contentious topic.
Yes, just the reality check about that culture. Let me just say, so the Department of Justice, even under President Obama, opposed the Sentencing Commission making drug reforms retroactive for whole categories of people. Right now, the whispering you're here is that maybe some of the people who are already out on home confinement because Bill Barr said they were safely out, maybe some of them won't have to go back because they'll get clemency. This is the smallest ball you can imagine. The compassionate release motions that are being granted, they're all being filed by defendants directly. BOP is filing an absolute teeny tiny fraction. So I just want to make a cultural change. Sure, it's possible, but we're probably looking at the kind of cultural change that would take decades, and people need relief right now. And the only other thing that I will add to that is, why keep it there? Do you think DOJ has an institutional or expertise advantage? What are they experts at? They are experts at prosecuting cases, but the clemency decision is asking a different question. It's asking a question about who this person is today, and DOJ has no relevant expertise in that. Sure, consult them and ask them questions if you have them about the underlying case, but that should be their role. They should not be the decision maker because they don't bring any expertise that makes any relevant sense to that inquiry.
All right, I'm going to move us on, just not because I don't think this conversation could keep us going and there's more to say, but in the Q&A, and I think it's a very important topic for us all to keep in mind and think about in this context specifically, and that's going to be the perennial topic of race and maybe disparities more generally. The federal system, as everybody involved here knows, has a less than sterling track record. I believe the House is supposed to vote just today on the Equal Act to level crack and powder sentences. That's maybe an example, Rachel, of you saying, hey, Congress, get your own house in order before you worry about how the president should use his clemency power. But, you know, my understanding of at least Obama's Clemency Initiative was driven, at least in part, by an effort to do what Congress didn't do, which was make fully retroactive the previous amelioration, though not equalization, of crack powder sentencing differences. And so I wonder if any of you want to speak to whether it's your own vision of how this could be done better, or, you know, a worry maybe, even if it's done better, that when it comes to racial issues, there's still more of a risk of exacerbating disparities. The one that I'll focus on, and one that I think is maybe Margie, your experience can speak to this, and even you, Rachel, representing through a pop-up clinic, you know, people with more money. It's not necessarily, you know, illicitly buying access. It may just be having good counsel that can put together a good clemency petition. At the end of the day, this is something that there's no right to counsel for. It's something that, you know, having resources to put a petition together, having people who will speak on your behalf, and whether it's done in a hopefully not too corrupt way, just in getting the word out, but often it inevitably is going to be, you know, who you know and how you can get their attention, in part because the numbers are so massive. And as you, I think, put it, Margie, this is inherently unfair. Whether it's on race issues, whether it's on socioeconomic disparity, do you think any of your proposals have, you know, sort of more going for it because relative to what we have now or what we could have, it at least is more likely to be aware of those concerns and try to address them? Or is it inevitable that this process, at the worst, at the best, mirrors existing disparities, and at the worst risks exacerbating those disparities across all these dimensions? And whoever wants to jump, I'll shut my camera off and you all can.
Doug, look, I mean, this is a terribly systemic problem. It's a problem with the justice system, the legal system, the criminal legal system. Even as to, for example, the home confinement cohort. It is not clear to me how the people were chosen to go to home confinement in the first place. I have 3 or 4 clients now that are in that cohort. I also know of 3 or 4 cases that are very similar that did not get chosen for home confinement. And I know that the profile of the population that is out on home confinement is probably not reflective of the racial profile of the federal prison system. Now that's an optics problem for the president that I hope he is in the process of fixing. But the problem of racism, systemic racism, I mean, it's a huge problem. It's the problem. And we just have to pick at it one strand at a time and do the best we can.
If I could just weigh in on that, I think one of the things that is helpful in that regard is doing the categorical relief of the kind that Paul talked about, because I do think when you make big categorical judgments and you get rid of that kind of, I'm going to look into particular arrest records in particular of people, that was one of the most frustrating things with the Obama initiative, was the attention paid to arrests. Policing in America is not an equal practice. And if you want to know which communities are heavily policed, they're communities of color. And so using arrest records is really a terrible way to go about things. But if you think about categorical relief, if you think about something like anytime a sentence reduction is going to happen, assuming Congress doesn't fix it with retroactive legislation, that the president's going to go ahead and grant that retroactive relief categorically, I think that's one way that you tackle that issue. And just, one footnote to the home confinement issue, I just hope that the way the Biden administration is planning on fixing that is to give more people home confinement who should have gotten it in the first place.
Yes.
So the pool does look like the overall prison population. The solution would not be to send the people who are already out back because they're a disproportionately whiter population, let's say. It's to give more people home confinement in the first place. And so, everywhere we look, I think the way we march to equality should not be more severity for everyone. It should be getting more people out.
Yeah, Paul, I don't know if you have comments or Jeff as well. Go ahead.
Yeah, I have a few. The first is on this subject, I think we can't ignore the fact that the RAND Corporation did a study of race and clemency and didn't find any evidence that there was racial discrimination in the clemency process. There may be mistakes made, but they said there was no evidence that was done on the basis of race. Now, insofar as the problem is that the sentences are too long, and that the offenders who are engaged in those sentences are predominantly Black or Hispanic, that's confuses, I think, two very different issues. It may well be that the sentences are too long. I mean, after all, it is, my experience growing up in New York City, the word on the street was homicide will get you, 7 to 9 years and you'll be paroled. So the idea that people are going to get 40 years for a lot of the drug trafficking crimes does seem to me, in many cases, to be excessive. But in terms of enforcing the laws, as Franklin Zimmering pointed out, if you use crime statistics to decide where to allocate your police, you're going to allocate police in neighborhoods where there is more crime. Now, if those are predominantly Hispanic or African-American communities, ignoring the fact that the people in that community, 99% of whom are not committing crime, creates a very different type of discrimination. You're leaving them victims of crime simply because you're afraid of arresting a large number of people of color who are committing crime. Well, we have predominantly Black, predominantly Hispanic neighborhoods, but you can't use the criminal justice system to try to address the problem we have in housing discrimination. That's dealt with in an entirely different manner. If you're not going to enforce the criminal law in neighborhoods that have high crime rates, you're leaving the people who aren't committing crimes in that same sort of status. And I think we can't just look at the race of the people who are being arrested and charged and convicted and sentenced. We have to look at the race of the people in those neighborhoods, because those two can cancel each other out.
Yeah, I think your comments nicely echo what Margie was talking about before in terms of, what do we want the pardon power to do if the goal is, to have clemency try to remediate some of the racial disparities we see elsewhere in the criminal justice system. That may end up looking like a very different system than if the goal is something else. And I think there's been some discussion, and for the benefit of those who may not know all the details, and I probably don't know all the details either, of this home confinement debate. There is a group of offenders who were sent home under the CARES Act, typically very low risk offenders sent home under the CARES Act by the Trump administration, Attorney General Barr, Justice Department screening them for being able to serve more of their sentence at home because of COVID concerns. And the interpretation of that CARES Act has come through the Justice Department as saying, when the pandemic is over, those still with time left to serve have to go back to prison. And that has been the focal point for considerable advocacy to change that possibility, because these individuals have been serving now, a year and a half at home, have had incredibly low rates of any other additional incidents to cause any problem. And so there's a strong and widespread belief that it would be more just and more sensible to allow them to finish out the duration of their term at home, or maybe have their sentences sort of fully commuted. What's interesting is the reporting from the New York Times, what seems to be going on now actively through the Justice Department's clemency process is an effort to identify drug offenders within what I tend to call the home confinement cohort. And I do wonder, Margie, I'm giving this background in part because I do think it may be with an eye towards racial justice. There's a sense that by focusing only on the drug offenders, you're more likely to have a more diverse population that benefits from clemency than if you look at the entire home confinement cohort, in part because, this is where I was going with all of this, it was largely a risk assessment that was being done by DOJ to determine who could be sent home on home confinement. And those risk assessments historically have been seen to skew towards less minority populations, that the way in which the very risk calculations are done, often considering arrests, considering criminal history, considering a range of other risk factors, doesn't end up with as diverse a population as other kinds of considerations. And so if the entire home confinement cohort were to get clemency relief, it might not reflect the diversity of who else is in prison. And that gets to, I think, Rachel's point. Maybe part of the analysis needs to be looking at who's still in prison for these lower level drug offenses and granting clemency to them in order to make sure the clemency grants are diverse, rather than forcing some people who need not otherwise go back to prison because they're low risk and have been doing well at home to go back to prison. And so it's going to be a very interesting first incident. I think, Jeff, this is what you're referring to about all the reports that the Biden administration may be using its authority here. And I assume this will get lots and lots of attention whenever it becomes a reality. And I guess maybe that's my sort of last question to the panel now is, we got a little bit more time, but my sense is they're going to try to do something this year. What the something is still to be determined. Do others have that feeling? Part of the do something so far has been not to change the process, right? And I think you spoke to this, Rachel, against the backdrop of not only President Biden's campaign promises, but what the entire Democratic Party was campaigning on in terms of change in this space. The decision not to change the process has not lived up to those expectations, but the sort of vague suggestion, I might put it that way, that there will be some clemency action soon leads me to wonder if you all are expecting to see something. This is our last panel, so it's a kind of a good forward-looking predictions, and it's on tape. So if you make the perfect prediction, we'll make sure to get you that tape again. And if you make a terrible prediction, we'll just, forget about this altogether. But, just kind of thoughts about what we can expect maybe this year and beyond, both as a matter of process, but also maybe as a kind of a hopeful matter of substance. And we'll go the same order kind of we started. So Jeff, I'll have you go first and then work our way around.
Yeah, I think politically it's a real risk to do thousands. You got the midterm elections coming up. It's a smaller subset. It's not a coincidence that we're targeting nonviolent drug offenders here, just like with Obama and his Clemency Initiative. I don't know what the right number is. I don't know if there's a safe number of these commutations that you can give. But if he does anything, he'll probably do, I don't know, not thousands. I'll say not thousands. Margie, maybe you have a better guess than I do.
Well, what I've seen, the paper that I've seen, suggests that it will be this year. That's my prediction. My prediction is that it will be north of 1,000, probably south of 2. I think, Rachel, your suggestion that they better hurry up and get a diverse population into home confinement is probably true right now. A lot of hurry up, catch up stuff. Can I just make one comment? And this sort of relates to this problem of implicit bias that I think was at work in choosing who went home. I just wanted to speak to the RAND report that Paul mentioned. The RAND report studied the operation of the pardon attorney. Yes, the RAND report found that there was no intentional discrimination. There was no evidence of discrimination. But what it did find is that the standards, the published standards for a full pardon that have to do with sort of returning home, get stable employment, contributing to your community, having good credit, not cheating on your taxes, etc. This described the profile of a white person. And the RAND report definitely concluded that the standards for pardon were resulting in a predominantly white cohort of people who were being recommended. So to that extent, I think this problem of implicit bias is throughout the system. I think that's what was at work in selecting who was going to be part of this home confinement cohort. So, it's a problem with any discretionary system. And it's for that reason, I'm inclined to really agree with my fellow panelists that categorical decisions, making sure that the category itself has been fairly developed and fairly selected, is probably the right way to go.
Doug, I think I'm up now. Let me make a couple points. One is, I believe that the president will not change the process along the lines of what either Rachel or I have recommended. president can only disagree with a cabinet level official on so many different issues. And this is not one that I see him disagreeing with Attorney General Merrick Garland on. Because in the process of disagreeing with him, he would essentially be agreeing with the actual or implicit bias point. And I don't think he wants to say that, because unless Garland agrees with that point, I can't imagine that the president wants to disagree with his own attorney general on such a public issue. So I can't see that happening in this administration. I do think he will exercise his clemency this year in connection with this home confinement issue, because it allows him not only to exercise some form of clemency, it allows him to tie it in to the whole problem of COVID. It's a way of saying, look, these people were originally released because they were at risk of COVID. They haven't reoffended. I'm willing to trust that they will continue to walk the straight and narrow. But I think in the process of doing it, what he'll do is essentially require them to agree to something like a condition of parole, which is if they do offend, then they forfeit the commutation that he is granting them by allowing them to spend the rest of their sentence at home. I haven't read the OLC memo, but my understanding is OLC has said these people have to go back to prison. I don't know, maybe OLC addressed the point whether the president could impose this condition as an exercise of his commutation power. But if it didn't, it's probably because they didn't want to get into the issue. If they did, I can't imagine them saying the president couldn't impose this condition that's similar to what we had for parole if he commutes the remainder of their sentence to home confinement. How many people are going to receive it? That I don't know. How many people who are still confined should receive it? That I don't know, because that turns on whether he wants to look at these matters on a case-by-case basis the same way President Obama did, rather than act in a categorical fashion. You know, he could say that somebody who served 75% of his sentence, who has had kept his nose clean in prison, automatically will serve the rest of his time in home confinement with the same proviso that he imposes for the people who already have benefited from home confinement. That would be a reasonable way of not only dealing in what would be seen as an eminently humanitarian way to address the people who've already been released, but also the people who were not yet released. Now, does it have to be 75% of the sentence? Not necessarily. That's an arbitrary number. I don't know what the best number is in this regard, but it wouldn't surprise me to see him say to his people, figure out how many people we can release based on the different percentages that they have served of their sentences. And then I will issue a commutation order that has the same parole type of proviso that I'm going to use in connection with the people who've already been released. And so I don't know. If he does this on a case-by-case matter, he'll be doing it from now till he leaves office, whenever that is. If he does it in a categorical fashion, which is the way I would recommend he does it, then it turns on the data, and he has to get the people at BOP and DOJ to give him the numbers. 90% of the sentence served gives you X, 75 gives you Y, 50 gives you Z, and that won't happen probably before close to Christmas. So since we're on the cusp of October, I would expect we would see a lot of these around Thanksgiving and Christmas, and maybe we should. Maybe this is a great way to get this process going. The exact number, I don't know.
Yeah, so I think my predictions are close to everybody else. I think he is not going to change the process, which is disappointing to say the least. And I think that they're going to try to use the home confinement as a marketing opportunity to try to pretend that clemency is working by taking a group of people that's already released and saying that giving them clemency shows that they can get the process to work, when in fact, in my view, that will be an abysmal failure because they're not even going to give clemency to all of those people on home confinement. But I think they're going to try to pump the numbers up with the home confinement folks with this attention to racial disparities. I kind of have Margie's instinct. It's going to be somewhere between 1,000 to 2,000, which is about half that population that's out. And then they're going to say this is a record number of clemency grants. No president in modern times has done anything like this. It's going to be great. And I just hope all of us who know know better, call them out on it for the fraudulent representation that will be, because that will not be real reform. That's status quo. In fact, it's worse than status quo because they'll be sending back the people who are already out. What would real clemency reform look like, even assuming they weren't going to make the process changes that I think are critical to it? I think it's the categorical relief that Paul is talking about. And here I'll just flag one more thing, which is that those mandatory minimums that people are out there serving in federal prison, the architect of those mandatory minimums, the head cheerleader for getting them passed in Congress, was often Joe Biden. And he has a pretty poor track record when it comes to criminal sentencing. And he knows it. It's not just the 90s, 94 crime bill that got a lot of campaign attention. He was there for the 86 legislation and then follow-up legislation in the 80s that had all these high drug mandatory minimum sentences. And although Congress reduced some of them, it didn't make any of those reductions retroactive, except for the crack retroactivity. And I just think he has, frankly, more than most presidents, some personal responsibility to face up to here, because there are people serving these mandatory minimums because of his efforts. And I hope all of the people who voted caring about criminal justice reform will pay really close attention to this, because, so far I give him a grade of F on this, and it's really disappointing. I know you got to give people lead up time, but every indication, every signal that they're sending suggests such a timidity on how to deal with these issues that, I hope I'm pleasantly surprised. I hope I'm not taking a darker view than is necessary, but they've sent no signal that they're prepared to do more. The only signal is to offer some far too modest relief for these home confinement folks and not to tackle those bigger questions. And if that is in fact what happens, he will have failed in his campaign promises. He will have the exact same track record he had when he was a legislator. And for anyone who cares about criminal justice issues, I would say it would be a failing presidency on that measure.
I will use my moderator's prerogative to add and pile on, because I do think the predictions are all really good, but I want to throw in, particularly inspired by Rachel's eagerness to make sure we don't give too much credit for doing too little. Fundamentally, and this connects to where we've been discussing earlier, this is a problem Congress made, right? That the OLC memo that says people have to go back is because they're interpreting the CARES Act to not be insightful, to say if people are doing well in home confinement, BOP at least ought to have discretion to keep people on home confinement. And to me, among the disappointments here, especially if it's what we're all predicting, is that President Biden and others are not actively pushing Congress to include in all the stuff that they're doing a little fix of that. Just the fix could be as minor as just give BOP discretion to keep people on home confinement if they're doing well after a certain period of time. And that's something that would, in its own way, not only allow the entire home confinement cohort to be properly treated, but it would mean Biden couldn't get this sellout or this opportunity to market some big clemency win that really is going to be his cleaning up a problem that Congress made, and not even cleaning it up fully, because at least as reports suggest, he's not going to grant clemency to everybody who's currently in home confinement with time to serve. And so you put all that together, and we see, maybe this gets back to where you started us, Margie. It's a shame when clemency can't serve its own function, and in fact has to do the work of Congress, has to do the work of other branches, including what I think are often mistakes or mis-sentencings, both coming out of DOJ and through the judiciary. And so there's a lot of work there to do. But with 5 minutes left to go, I want to give everybody, I got my last word in that way, give anybody else who wants to sort of get a last word in, although, us professors are the only kinds of lawyers who have clients that like it when we end early. And so, if class gets dismissed a few minutes early, that's fine. Don't feel obliged to throw in a minute of final thoughts, but I'm so grateful, and I want to say thank you to all of you. And I want a special round of applause for Margie for all the work she's done on this entire series of terrific panels that, reminder to all, will be available on recordings. But you get the last word for the last panel if you're so inclined, but try to keep it to a minute or two at most, since we're running out of time. And thank you again. So anybody wants to jump in, go right ahead.
Doug, let me jump in. I want to thank you and Margie again for inviting me to be on this panel. I always learn when I listen to bright people, and there are 3 other very bright people on this panel. I want to say thank you. I want to say, insofar as the problem is the sentences we have, particularly for drug offenses, are too long, only Congress can address that going forward. Congress needs to address that going forward. Even little things like making future reductions retroactive should be done. The president, not just Biden, every president should be more active in the clemency area. We've given different ideas how it can be done. The current system isn't working as well as any of the other proposals that we heard today. I hope Biden or somebody on his staff is listening and he decides to make some of the changes we've talked about. Again, thank you very much.
Well, I want to thank Doug and Steve and the federal sentencing reporter and all of my co-authors and colleagues and panelists for an opportunity that for me was just a terrific opportunity to sort of envision what law reforms might be made and what reforms in the pardon process might be made. I mean, I've been waiting 25 years to do this. And, you know, having been in charge of that hen house for almost a decade, I can say that it really needs to be cleaned up. I think there are lots of small statutory changes that can be made. Giving BOP general authority to extend home confinement is one of them. It has a mingy little 6 months max or 10%, whichever is less. That's just a small authority. And I know when I was a deputy attorney general's staffer back in the 1980s, Mike Quinlan, who was then in charge of BOP, tried to do that. And I, as a staffer, said, no, you can't do that because the law doesn't let you. But I really feel bad about that. And I think it's time for Congress to fix it. And I'd like to also see Congress do something about the restoration of rights issue, whether it's expungement or sealing, whether it's judicial certificates, whatever it is that will relieve collateral consequences and allow people to go forward as full functioning citizens without the burdens of all these collateral consequences. I think that's tremendously important too.
So I've had a couple last words here. I think you all know my general take, but I guess I'll end by saying it's not just that the Biden administration has done nothing on clemency. Where's their leadership and where's their voice on the legislation? Where's their leadership and their voice on all these problems? It's silence. And I think if they really cared about these issues, then they maybe, if they have a philosophical objection to using clemency for this kind of relief, I don't agree with that, but I understand it, and they could state it, but then they could say that's why they're doubling down to get the legislative reforms, but they're not doing that either. And I'll just point out, we've seen this before. You know, it was also true during the Obama administration. I know he didn't want to use clemency to fix all the problems that were out there, and he said as much, but it was also true that DOJ was stopping a lot of really good legislation from getting passed. And so at the end of the day, I think when you judge an administration on what it's doing with criminal law, yes, you judge it on clemency, but you also judge it based on what they're asking for from legislation. No one has more influence with Congress than the executive branch and what it's requesting. And I haven't seen any evidence that they've cared about it on that front either.
I would just like to say thanks for including me in this. I enjoyed writing the piece that went in Federal Sentencing Reporter, and it's great to be on a panel with all of you all. This week is the American Political Science Association annual meeting, and a different crowd. And so this is a much more different conversation than some of the ones I'm having there. So this is fun. And hearing the plans that Rachel and Paul are putting forward, really compelling stuff. Reading it on paper is one thing, and hearing it, hearing the case made is a totally different experience. So thank you all for letting me participate in this. Appreciate it.
Well, thank you, Professor. And thanks to, again, Margie and everybody else involved. And thanks to all the attendees. Grateful you stuck it through the 90 minutes and hopefully you thought it was time worthwhile. And we don't have another panel to preview, but we have obviously predictions to see if they come true. I look forward and hope to hear from any and all of you interested in these topics, because it's something that's going to be continued work for all of us behind these panels, and is really going to be something to watch for this administration and those to come. So thank you all, and be well and enjoy your afternoons. Thank you. Take care.